Hello, welcome back, lawyers and learners. In our previous lecture, we laid the groundwork by studying the background and a broad overview of the Hindu Marriage Act of 1955. Now that we have understood the framework of the Act, we are moving to a very practical topic, that is registration of Hindu marriages. At first glance, registration may look like a simple administrative step. You may even think, sir, registration simply means getting a marriage certificate, right? But legally, the topic goes much deeper. The central idea of today's lecture is this: registration proves a marriage, but it does not perform the marriage itself. Section 8 of Hindu Marriage Act does not create a marriage, it records a marriage that has already been validly performed. So today in this lecture, we will understand the meaning of registration read under Section 8, compare it with Section 7 and understand the procedure, and then discuss important cases like Seema versus Ashwani Kumar and Doly Rani versus Manish Kumar Chanchal. Before we read the bare act, let us first understand the most important distinction. A marriage certificate is not the same thing as a marriage. Similarly, registration is not the same thing as solemnization. Solemnization means actual performance of marriage according to law, custom, rites and ceremonies. Registration comes later. It records the fact that such marriage has taken place. So Section 8 records the marriage that has already been validly performed. It does not perform the marriage. The distinction is extremely important for exams, court practice and real life disputes. So you need to emphasize on this core idea very clearly, that registration proves but it does not perform a marriage. Now let us understand what is registration of marriage. Registration of marriage means official recording of the fact that marriage has taken place. This record is maintained by the state authority, usually by marriage registrar, by the sub registrar or some other authority which is notified under the relevant state rules. Once the marriage particulars are entered into the register, the authority may issue a certificate extract, which is commonly called as the marriage certificate. Why this is important? This is important because disputes do not arise about the rights within marriage. Many times the dispute is about whether the marriage exists at all. One party may say that we are married, while the other party may deny the marriage completely. This may arise in maintenance cases, inheritance related dispute, child custody matters, residential rights, and even in cases where nomination within the bank is involved. In all these cases, marriage certificate is very important because it gives a documentary proof from a public authority. But remember the limitation. A marriage certificate is a strong evidence, but it is not the marriage itself. A marriage certificate cannot create a marriage where no valid ceremony has been done or a legal requirement has not been fulfilled. That is the central theme of today's lecture. Now let us look at the bare act. Section 8 is titled Registration of Hindu Marriages. The opening words are very important here. The section begins with the word "for the purpose of facilitating the proof of Hindu marriages." Now you see these words, mark these words. The statute itself is telling us the purpose of Section 8. It does not say for the purpose of creating a marriage. It does not say that for the purpose of solemnizing a marriage. All it says is that for the purpose of facilitating a proof. So Section 8 is an evidentiary provision. It is about proof, record and legal evidence. But it does not perform the marriage ceremony. So while reading Section 8, always keep this point in your mind, that it is a proof and record and it does not mean solemnization of marriage. Now let us break down Section 8 clause by clause. Subclause 1 gives the state government the power to make rules for entering marriage particulars into Hindu marriage register. This is why the exact forms, the fees, document, witness and appearance requirements may differ from state to state. The Central Act gives broad framework. The state rules provide the working mechanism. The subsection 2 allows the state government to make registration compulsory. It also permits a fine for failure to comply. The original fine mentioned in the act may look very small today, but the legal point here is that the state has the power and authority to make it mandatory that everyone should register. The subsection 3 says that rules made under Section 8 must be laid before state legislature. Subsection 4 is very important for evidence. It says that the Hindu marriage register is a public document. It is open for inspection at reasonable times. Certified extracts from it are admissible as evidence in the court of law. This means that certificate has legal value. Now comes subsection 5, which is very important. It says that the validity of any Hindu marriage shall in no way be affected by the omission to make the entry Means if someone has forgotten or has deliberately not issued a marriage certificate, it does not mean that the marriage does not exist. Non-registration will not destroy or invalidate a marriage. But the flip side of the rule is also true, that registration does not cure an invalid marriage. If the essential legal requirement or ceremonies are absent, if there is no solemnization in a marriage, for example, registration will not affect that defect. Means the marriage will remain defective if solemnization has not taken place, and even registration will not cure it. So the conclusion is, non-registration does not invalidate a valid marriage, but registration does not validate an invalid one. Now here we are going to compare side by side section 7 and section 8. Section 7 talks about solemnization, whereas section 8 talks about registration. Section 7 concerns the actual performance of the marriage. It refers to customary rites, ceremonies of the either party. Where Saptapati is part of the ceremony, the marriage becomes complete when the seventh step is taken. Therefore, section 7 talks about the legal existence of the marriage, and section 8 talks about the registration in or making a entry into a public register. Section 8 creates documentary proof. It makes register and certified extracts useful as an evidence. But section 8 cannot complete a marriage by itself. So the rule is very simple, that certificate is not equal to marriage unless there is a valid marriage to certify. If there was a valid marriage, registration helps to prove it. If there was no valid marriage in first place, registration cannot perform a marriage. Let's move on to the next slide. Now the question is, to whom does this act apply? So this act applies to whoever is a Hindu, and if you have seen lecture 1 in this series, you will understand the definition of a Hindu. Hindu are people who are not Muslims, not Christians, not Jews, not Parsis, and Hindus will also include Buddhists, Jains and Sikhs. So section 8 applies where a marriage is legally a Hindu marriage as per this act. So you cannot take a marriage that is governed by a completely different personal law and convert it into Hindu marriage merely by entering the name into Hindu marriage register. Also remember that registration is implemented through state rules. So a lawyer should always read section 8 along with the relevant state rules or local registration laws. These forms, fees, documents, witness, mode of appearance and compulsory registration requirements may vary from state to state. So now let's move on to the next slide. The exact procedure of a marriage registration depends upon state rules, as I already said, but the usual flow is similar. First, there is an application. The parties file the prescribed form before the local marriage registrar or sub-registrar or the notified authority. Secondly, there are documents involved, usually identity proof, age proof, address proof, then photographs, proof of solemnization and witness details are also required. And thirdly comes verification, where the authority verifies the particulars. Depending on the rules, the parties and the witness may be required to appear and sign before the registrar during verification. And the fourth step is the entry into the register. If the authority is satisfied with the marriage particulars, they will enter the name into Hindu marriage register. The fifth and the last step is issuance of certificate. A certified extract or marriage certificate is given on payment of the prescribed fee, which will vary from state to state. So the process is practical and very administrative in nature. Now let's move on to the next slide. Now a question I want to ask you people is, as I said that if you perform solemnization, then marriage is completed and it is also legally valid. Then what is the importance of having marriage certificate? The answer to this is that marriage certificate acts as a evidence from a statutory authority. It helps avoid unnecessary dispute about the fact, the date and the place and particulars of the marriage. It protects the rights of both the parties. It assists claim relating to maintenance, inheritance, residence, custody and even service benefits. It is also useful in administrative matters such as passport, visas, bank record, insurance, nominations in bank and employment records. There is also a social safeguard associated with this, and compulsory registration helps deter child marriage, bigamy, desertion and false denial of marriage. So a marriage certificate is not merely a paper formality, it is useful legal document. But again, we must not confuse the value this is having only evidentiary value and it does not perform the marriage and is not equal to solemnization of the marriage. Now let us move on to the next slide. Now comes the landmark case of Seema versus Ashwani Kumar of 2006 before the Supreme Court. In this case, the Supreme Court recognized the hardship caused by the lack of proof of marriage. Even though Section 8 gives much power to the state and even though non-registration does not invalidate a valid marriage, the court treated registration as a serious social and legal necessity. In this case, the court observed that marriage of all citizens, irrespective of their religion, should be registered in the place where they are solemnized. Now, registration is a very good step because it is a step towards good governance and it protects rights, reduces false denial of marriage. Marriage certificate can also support presumption of marriage. Though this presumption remains rebuttable, the judgment of Seema versus Ashwani Kumar pushed state and union territories to frame or improve rules related to registration of marriages. Seema versus Ashwani Kumar promotes registration as a social protection. Now let's see next case law, which is that of Doly Rani versus Manish Kumar Chanchal. The case of Doly Rani versus Manish Kumar Chanchal is a recent case of 2024. This case actually established the relationship between Section 7, that is solemnization, and Section 8, that is registration. In this case, this couple admitted in court, before the court, that they did not do solemnization and yet they had marriage certificate and it was admitted by them in the court. So the question was, can a certificate of registration give the parties the legal status of husband and wife when the essential ceremonies under Section 7 never took place? The Supreme Court said no. Section 8 only facilitates proof of a Hindu marriage already solemnized under Section 7. Registration cannot create or legitimize a marriage where no ceremony had taken place. On those facts, the certificates and registration were treated as null and void. This case gave us the clearest and most modern rule that registration proves a marriage but it does not perform a marriage. Seema versus Ashwani Kumar case, it promotes registration. Doly Rani in a way you can say preserves the customs such as solemnization. Both these cases are consistent. One says registration is socially important and other says that you cannot replace a mandatory ceremony or a custom. Now let us see some other important judicial precedents. These are from high courts. One is from Kerala High Court and other from Madras High Court. The first one is Nishana Mole versus Alappuzha Municipality. Now in this particular case, the issue was whether both parties must be personally present during the time of registration of marriage. Suppose if one person, say husband or a wife, resides abroad, does he or she have to be physically present before the registrar? The court explained that registration rule deal with marriage already solemnized. The registrar is just merely recording that marriage has been completed and a valid marriage exists. The registrar is not solemnizing the marriage. Therefore, presence of both the parties should not be insisted rigidly unless the rules require it or the registrar has a genuine doubt about the identity or the material facts disclosed during the application of marriage certificate. The second case is that of Arunkumar versus Inspector General of Registration. This is a case from Madras High Court in 2019. In this case, a Hindu male and a trans woman had married according to Hindu rites and they had sought registration. The registrar refused registration partly on the grounds that trans woman cannot be treated as a bride. The court rejected that narrow view. It held that a trans woman's identity as a woman can fall within the expression bride and the registrar cannot refuse registration on that ground. This judgment reflects constitutional values of dignity, autonomy and self-identification. So the broader point here is that courts apply registration rules pragmatically while preserving proof, dignity and access. Now let us quickly revise what we have studied in this lecture so far. Firstly, Section 8 is mainly about the proof of marriage. Secondly, it is the state that will decide the exact registration procedure. Thirdly, the register and certified extract are admissible as evidence in the court of law. Fourth, non-registration does not invalidate a valid Hindu marriage. And finally, the fifth point that we learned is registration cannot validate a marriage that was never solemnized under Section 7 of Hindu Marriage Act 1955. So the final rule that we need to keep in mind as a one-liner is that registration proves a marriage, but it does not perform a marriage. A registration certificate is powerful evidence, but it is not a document that will perform a marriage by itself. The legal foundation of Hindu marriage lies in a valid solemnization taken place in accordance with Section 7. Now this raises the next question. If a certificate does not make a marriage valid by itself, then what are the actual conditions required for a valid Hindu marriage? That takes us directly to our next lecture, where we will study Section 5, which includes essential conditions for a valid Hindu marriage. Thank you for joining me in this video. I will see you in the next lecture.